certainly
That's outside the scope of cross-examination. Get out.
Okay. You're not whacked out on PCP right now, are you?
No.
Okay. And we're in a courtroom right here with sheriff's deputies, and we're surrounded by, we have a judge right here, so it's not real life, right?
I feel very safe.
Okay. But on the night in which Jason Van Dyke met LaQuan McDonald, there wasn't any protection, such as being in a courtroom with deputies and people all around, correct?
That's correct.
It was a dangerous, real-life situation, correct?
Yes.
Nothing further. Thank you.
Mr. Cullen.
Now, you've looked at the videos, you've looked at the reports, and your testimony that there was no protection that Jason Van Dyke had. Is that correct?
I said there was no physical barriers between himself and Mr. McDonald.
You just told Mr. Herbert there was no physical barriers, or did you just say there was no protection?
I'm not sure.
Because there was significant protection that the officers had that night, wasn't there?
I'm going to object to the officers. Talking about my client, that's fine.
Well, do you understand the question?
I do. I just don't understand what you mean by protection.
Well, Jason Van Dyke had a pistol, is that correct?
I'm sorry?
Jason Van Dyke had a firearm, did he not?
Yes.
He had a partner standing next to him with a firearm, didn't he?
Yes.
He had a squad SUV, is that correct?
Yes.
Capable of knocking people over, is that correct?
It could.
He had a bevy of other Chicago police officers immediately around him, did he not?
And what you mean by immediately?
Well, within his sight on Pulaski Street in Chicago.
So that's immediate. So I'm not sure if that was in Officer Van Dyke's sight. There were other officers present.
Okay. Was there anything that would have prevented Officer Van Dyke, before he approached LaQuan McDonald, from seeing the squad car that was following him?
Anything that could have stopped him from seeing it? No.
Any reason for you to believe that he didn't know that there was a squad car immediately behind him?
I don't know if he knew that or not.
Okay. Because he may not have been paying attention?
Absolutely.
Okay. And was there anything preventing him from knowing that Officer Velez and her partner were in a squad car right next to LaQuan McDonald before the defendant got out and shot LaQuan McDonald? Anything preventing him from seeing that?
If he didn't look that way, yes. If not, I'm not sure.
Okay. And what about the other squad cars that are shown in the video with their lights flashing? Would there have been anything else, or anything that would prevent the defendant from knowing that he had that protection available to him?
Again, the fact that there's other officers there, I'm not sure if Officer Van Dyke would consider that protection.
And the fact that the radio dispatch indicated that there was a taser on the way, which arrived about 20 seconds after the shooting.
That's not the evidence. No evidence that there's a taser on the way.
Sustained.
That a taser had been called for, and an officer responded, "We're on the way."
Objection, not the evidence.
The jury's heard the evidence. The other thing is he rephrased. Go ahead, Mr. Cullen.
I have no further questions, Your Honor.
Thank you. Thank you very much.
All done?
Thank you. Could I have the attorneys over here for a second, please? Ladies and gentlemen, again, you've been fantastic. This is the first time I said it today. I apologize. I usually get it out 2 or 3 times. So keep up the outstanding work. We have completed evidence for today. We'll see you all tomorrow. Safe trip home. Be careful.
All rise for the jury.
Okay, will everybody please be seated? Thank you. At this time, we're outside the presence of the jury. All the parties are present. Mr. Herbert. Ms. Nguyen, excuse me.
Thank you. Judge, this time we asked to admit certain exhibits into.
Why don't we do this one at a time? See, unless have you conferred with the state? Why don't you do that? All right, then you might be able to admit a lot in. You have to go over there, Tim. Pardon? No, I know, I'm just kidding. Yeah, sure. John, could you move that, please? Just to keep everybody up to what's going on, the defense and prosecution are going over the evidence that the defense has presented. Then they're going to see which ones the state are going to object to, if they're going to object to any of the exhibits. And if they don't, or if they do, we'll have a hearing on it. And then at that time, they'll move the exhibits in evidence, which will be the ones that will be properly admitted into evidence. Then tomorrow morning, the defense will rest, and then the state will put on their rebuttal. So we're getting towards the end.
Judge, on that note, I think we're going to have to the state to provide us an offer of proof as to the witnesses that they plan to call.
Well, go ahead. Nobody's holding you in your seat, right? Go ahead.
Ask the state to provide an offer of proof for the witnesses.
Well, go talk to them so you find out. All right. There you go. All right, let's do this. Let me know the ones that you have agreed upon and no objection, so we can get something done. Let Ms. Went do this.
Defense number 6, video number 4 from Patterson.
I have no idea what you're doing, all right? Are you moving those into evidence?
Right, these are the ones that are, actually, these are the ones that are.
You're not moving the states,
Into evidence.
you're not moving the states documents or videos into evidence, right? All right. Hello?
So, great, Judge, defense exhibit 6, 7, 8, 11, 12, 15, 16, 20.
No objection, state? They will be moved into evidence. The identification marks will be stricken. What's next, if any?
The tire, Judge, we have a stipulation as to the tire that will be.
You have physically have the tire here?
Yes.
Okay. I believe you. All right, good. All right, no objection, state? All right, well, it's a stipulation. I'm sorry. Go ahead.
And then there's several other items that have not been admitted into evidence that are demonstrative. That's it. That's it as far as the.
Okay, thank you very much. And then you can formally rest tomorrow. When the jury comes back tomorrow, it's okay, Chip, you're not talking, so you can leave if you want. Don't worry about it. Here's the thing, is what we'll do is when the jury comes back tomorrow, we'll call them out and you'll say, consistent with your rulings on the evidence, Judge, at this time the defense rests. And then I'll tell them that this is it, you completed your case in chief, and then the state will go forward with their rebuttal. And you have an exchange of ideas and between Mr. Herbert and Mr. McMahon, is that correct?
Yes.
Okay. Outstanding. All right. We're in recess till tomorrow.
Bye-bye.